Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli, and Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by Cerenade e-immigration. I recently caught up with the folks at e-immigration who shared a big announcement. Hot off the presses. Have you heard? E-immigration is now integrated with the VisaLaw.ai. Over 10,000 users can now connect their e-immigration accounts to VisaLaw.ai, allowing them to generate expert letters, court documents, petition briefs, and entire case packets directly within their case management system. It's case management meets modern drafting, so you can build stronger cases faster than ever. The combination of e-immigration and VisaLaw.ai means what used to take hours can now be done in minutes. Just think how much faster your immigration workflows can be. Learn more at get.eimmigration.com/VisaLawAI, or of course, click on the link in the show notes. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. It is 6:30 a.m. on Saturday at the AILA National Conference in Denver, and I am sitting at the end of the hall of the Cottonwood rooms in the lower level. I am doing so because the rooms I had hoped would be available and quiet for recording on this Saturday morning are either locked or playing Stevie Wonder's She's a Bad Mama Jamma through the ceiling speakers. While I cannot be mad at that and naturally do not object to the message of bad mama jamminess, it's not ideal for podcast recording. I'm doing it at 6:30 a.m. to avoid the cute little 10-month-old who is still sleeping in my hotel room. Many of you would have met him at this conference and can attest to his cuteness and the truth of his outro review on each episode. I needed this conference. I know many others did too, and it did not disappoint. Well done, AILA! In times of trouble and stress, we need our tribe. This conference and everyone I met delivered and provided some much-needed motivation to go forward. Oh yeah, and Mahmoud Khalil was released from immigration detention on Friday. Simply incredible advocacy by so many. Only a few hours before his release, his attorneys were discussing the case to a small group litigation meeting in the lowest level of the AILA National Conference. Some of the most important immigration litigators today were also in that meeting talking about their exceptionally important cases, and well, I am inspired by all of them. Then a few hours later, those attorneys for Mahmoud Khalil were in federal court arguing for Mr. Khalil's release, and they succeeded. Incredible stuff. Litigation is how we fight back, guys. Federal court is the backbone of America. I am grateful to be part of the fight and for all those litigators kicking butt for their clients and the country. Nothing is certain, so we keep fighting. Nothing is guaranteed, so we file the lawsuit. Nothing is inevitable, except the BIA publishing a non-citizen adverse decision every single week now. So here's that, and two more, from Denver. Our first case is Gonzalez Castillo v. Bondi, published by the Sixth Circuit on June 18, 2025. This case is about denaturalization, crimes of child abuse, abandonment, or neglect, and removal. It's the third decision on this issue or a similar one in recent years, if I'm not mistaken, and well, it looks like a bit of a movement is underway. Mr. Gonzalez has lived in the United States since 1981. Looks like he became a lawful permanent resident in 1989, either through amnesty or the SAW program, both Republican administration programs, and then he applied to naturalize 2 decades later afterwards. Quote, he succeeded, but not with clean hands, end quote. While the application was pending in 2009, Maryland law enforcement officers arrested Mr. Gonzalez and charged him with 7 counts related to the sexual abuse of his minor niece. He had a naturalization interview after that, but he didn't disclose the arrest. He naturalized in October 2009, and then 2 months later, pled guilty to 1 count of sexual abuse in the 3rd degree in Maryland. The U.S. government eventually figured it out, filed a lawsuit to denaturalize Mr. Gonzalez in federal court, and succeeded. A federal judge found that Mr. Gonzalez had illegally procured his citizenship as described by 8 U.S.C. Section 1451A. So now he's a lawful permanent resident again, right? DHS initiated removal proceedings to remove him, charging that his Maryland offense is a crime of child abuse, abandonment, or neglect, as described at I&A Section 237A2EI. And you know what? It probably is, meaning that any other LPR with this Maryland conviction would likely be removable. But recall, Mr. Gonzalez is not any other LPR. He used to be a U.S. citizen. And vitally, even though he committed the offense when he was an LPR, he was convicted after he became a U.S. citizen. Why is that vital? Because of the statutory text of the removal charge, which, if the Sixth Circuit's Loper Bright citation is intended to mean anything, probably means that the Sixth Circuit is saying that it doesn't care what the BIA has said previously on this issue. I&A Section 237A2EI states that, quote, any alien who at any time after admission is convicted of a crime of child abuse is deportable, end quote. So like the aggravated felony removability provision and probably almost all other Section 237 provisions, it applies to, quote, any alien, end quote, who, quote, is convicted, end quote. A U.S. citizen is by definition not an alien. It is for this reason, for example, that the I&A largely doesn't apply to U.S. citizens. It's all about aliens, non-citizens, in modern phrasing. Now, of course, Mr. Gonzalez was technically convicted after his admission into the United States. But there's more to this removal provision. Quote, the phrase, is convicted, also uses a present tense passive voice structure. That suggests that the child abuse provision covers only the removal of an individual who is an alien at the time of the conviction, end quote. And that's a big deal holding. The Sixth Circuit relies on precedent old and new in support. It all starts with the Supreme Court's 1964 Castillo decision, which relied on similar logic with the old I&A statutes. With that decision on the books for so long, quote, Congress had ample reason to understand Castillo's position on this language when it adopted the child abuse provision in 1996. And it retained the relevant wording wholesale, end quote. That is the stuff about the removal language applying to someone who is an alien at the time of conviction. Want further support? Look no further than Section 237 itself, explains the Sixth Circuit. Not all of the removability provisions only apply to an alien who is convicted. Some, like I&A Section 237A2BI, refer to an alien who, quote, has been convicted, end quote, of a controlled substance offense. That's different, right? And then subsection BII is even more specific, referring to an alien who at any time has been a drug abuser. So that's pretty expansive language, but the child abuse provision does not include it. That tethers it to an alien who, quote, is convicted, end quote. And well, quote, it's fair to infer that the contrast stems from Congress's proper use of grammar, not a sixth grader's halting grasp of verb tense, end quote. Ouch. Was that really necessary, Sixth Circuit? Don't get me wrong, I'm here for it. The Third and the 11th Circuits reached very similar conclusions recently with the aggravated felony removability provisions in Singh and Hilton, episodes 71 and 49 respectively. Quote, we know of no contrary circuit precedent, end quote. Not only does the statute demand this conclusion, but so does the rule of lenity, which might make this the first successful rule of lenity argument discussed on the podcast. Quote, when such uncertainty clouds a deportation statute, the long-standing principle of construing it in favor of the alien kicks into gear, end quote. That is, the statute should be read in favor of non-removability. That's a pretty big deal, too. rejecting a bunch of Oil's smart arguments and providing an absolute roadmap on how to argue this issue in the other circuits who have not yet ruled on this largely Supreme Court-based argument, the Sixth Circuit very much ruled in favor of Mr. Gonzalez. Indeed, for any time Oil or your opponent argues for a broad reading of a removability provision based on Congress's alleged desire to combat a certain evil, quote, the text of the statute reflects the reasoned compromise of 535 legislators and one president, and an amorphous purpose cannot replace the enacted text, end quote. If that doesn't get you going, well, you are not yet sufficiently a nerd. Judge Thaper begrudgingly concurred. So, of course, congratulations Ben Winograd for petitioner. A word of caution. Small caveat, unless I've missed something, Mr. Gonzalez probably can never leave the United States because on his return, DHS can probably treat him like an applicant for admission, mandatorily detain him, and likely secure his removal. That is because that things like CIMT inadmissibility permit DHS to treat returning LPRs as applicants for admission and charge them as arriving aliens, and the inadmissibility provision isn't limited to an alien who is convicted. In fact, most inadmissibility provisions don't even require a conviction at all, including CIMT inadmissibility. But still, big win for a person who wants to remain in the United States and for statutory interpretation everywhere. And that is Gonzalez Castillo v. Bondi. Moving on to matter of Roque-Izada, published by the BIA. The BIA is back again this week, like they seem to be every week now, with a decision adverse to non-citizens. And on the Friday of the AILA National Conference, what gives, BIA? The non-citizens bar is in such good spirits. I do not take this kindly, this clear attempt to rain on our parade. No, I do not take it kindly at all. The parade will go on after this case, which is about termination of proceedings. A long time ago, way back in, say, October 2024, a similar fact pattern to this case may have been terminated by immigration judges and the BIA and sustained. No longer, says the BIA. And actually, yes, an immigration judge did terminate this case. The BIA just doesn't like it on DHS's appeal. Mr. Roque-Izada is from Cuba and had his removal proceedings initiated in 2022. A few things are going on here. It seems like Mr. Roque-Izada may have entered the United States unlawfully, but he claimed in these proceedings that he was then paroled under I&N Section 212D5, a qualifying parole. But as a matter of law, that parole was terminated, explains the BIA, when DHS filed the notice to appear in this case. To the BIA, that meant that Mr. Roque-Izada reverted back to an iwi, someone who entered without authorization, and he is removable for that reason. Which I do believe is true, but also, I wonder what's going on with this parole. And does it matter? After all, Cubans are special. A year after they've been paroled into the United States, they're eligible to adjust to LPR status. Unlike all other non-citizens, they have this very easy path. They just need that qualifying parole. And so that's what Mr. Roque-Izada was trying to do after a year. He wanted to pursue adjustment of status before USCIS, but needed an immigration judge to terminate his removal proceedings first, or else USCIS wouldn't have jurisdiction. And IG did so, and DHS appealed, arguing that Mr. Roque-Izada wasn't eligible to adjust, so he shouldn't have his case terminated. The BIA agreed with DHS. As the BIA explains, Attorney General Garland's decisions and regulations permit termination of proceedings when, quote, it is necessary for the respondent to be eligible to seek immigration relief before USCIS, end quote. I don't believe that that's the only circumstance where termination is warranted, but it is one. The relevant regulation is found at 8 C.F.R. Section 1003.18d, by the way. Now, except for arriving aliens, yes, termination of removal proceedings is necessary for someone to adjust status before USCIS. But as the BIA explains here, termination wasn't necessary. Immigration judges have authority to grant Cuban Adjustment Act adjustment of status just like USCIS does, even for people who entered without inspection, so long as they have a qualifying parole. The BIA's matter of Cabrera Fernandez decision from episode 177 did not hold otherwise, explains the BIA. So that's something, everybody. That's something. But then the BIA held that Mr. Roque-Izada hadn't established that he was actually paroled in the United States pursuant to INA Section 212D5, a qualifying parole. Rather, the BIA seems to think that this is the same type of conditional parole that was at issue in matter of Cabrera Fernandez that doesn't count as a qualifying parole for Cuban Adjustment Act purposes or any other adjustment of status purpose. Like, it's simply a release from DHS custody type parole rather than a true 212D5 humanitarian parole. Go back and listen to matter of Cabrera Fernandez for all that distinction, although there wasn't much analysis in that decision if I recall, and also the matters on petition for review to the 11th Circuit, so hopefully we'll get some clarity soon. Also, though I admit I'm confused, this is confusing stuff and there's not much in this decision, but if it wasn't an actual parole, then what was terminated when DHS served the NTA in this case? The conditional parole was terminated, which to the BIA is little more than simply a release from custody? I am confused. Such a person would have always been an iwi under the BIA's logic in Cabrera Fernandez, right? So what is the parole that the BIA said was terminated here that has legal significance? I'm confused. Probably because it's a short decision. So someone message me. But to the BIA, it all meant that there weren't grounds for the IJ to terminate removal proceedings. So, the BIA sustained DHS's appeal. And that is matter of Roque-Izada. Are you fighting like a maniac, completely overwhelmed by the chaos of the new administration? Immigration policies are shifting fast, the pressure is piling up, and clients are desperate for help. You're working around the clock, but there's only one of you. Well, Staffy's got your back. Staffy's bilingual virtual paralegals and administrative assistants handle USCIS forms, client intake, evidence gathering, and scheduling, so you're not drowning in paperwork while trying to fight for your clients at the same time. Stop running on empty. Staffy gets you a trained, ready-to-go team fast with HR-backed support, onboarding, and continuous training. You don't have time to do it all alone, and you don't have to. Schedule a consultation at staffy.cc, that's stafi.cc, and claim $500 off your first month.
Immigration attorneys. Once you've secured a bond, let Gonzalez and Gonzalez Immigration Bonds take it from there. They help families post immigration bonds quickly, easily, and with full support every step of the way. Sure, you can post directly with DHS, but that means no guidance, no help when something goes wrong, and a 4 to 6 month wait for a refund. With Gonzalez and Gonzalez, families get hands-on help throughout the entire process, and they typically issue refunds within 1 to 2 weeks of receiving the I-391 bond cancellation notice. Tired of being the point of contact for every bond question? Let Gonzalez and Gonzalez take those calls. They'll handle the paperwork, the system issues, and the family's concerns, so you can focus on what really matters, winning the case and helping your client stay in the country. You can reach Gonzalez and Gonzalez at 833-409-9200. Their fee? Just 2% plus $40. And for bonds of $10,000 or more, they can defer the fee and deduct it from the refund. Financing options? They got those too. They're family-owned and have been in business for 75 years. Gonzalez and Gonzalez Immigration Bonds. Efficient, supportive, and trusted. Visit immigrationbond.com, click on the link in the show notes, or call at 833-409-9200.
Our last case is Lemus-Escobar v. Bondi, published by the 9th Circuit on June 16, 2025. This is a very, very long one on hardship, mental competency, asylum, reopening, NACARA. It's just a lot. Judge Jack Zari, United States District Court judge from the Northern District of Ohio sitting by designation, concurred and dissented. Mr. Lemus-Escobar is from Guatemala and has been living in the United States without authorization since 1985. He's been in proceedings or otherwise trying to remain in the United States since 1992. There is so much going on. I'll try to take it one step at a time. Looks like he might have affirmatively applied for asylum in 1992 and lost? Or maybe it was applied for in deportation proceedings. In 2000, he applied for cancellation of removal pursuant to NACARA. And we'll get into that a bit. And then somehow he ended up in removal proceedings in 2008, where he applied for regular cancellation of removal. That was eventually denied too. In addition to credibility, quote, in particular, the IJ concluded that two of petitioner's criminal convictions for shooting an inhabited house in 1988 in violation of Cal Penal Code Section 246 and for causing corporal injury of a spouse in 1993 in violation of Cal Penal Code Section 273.5a were crimes involving moral turpitude, end quote. New counsel then appealed that to the BIA and by this time had a deficient NTA issue to bring up. New counsel argued that actually Mr. Lemus-Escobar had indicia of incompetency as well. He did have an attorney below, though. The BIA dismissed the appeal. And in 2019, Mr. Lemus-Escobar moved to reopen with hundreds of pages showing that his health was declining and he had a new fear of return to Guatemala. The BIA denied that too, and it's all now before the Ninth Circuit. The Ninth Circuit had 6 issues to address, in addition to the motion to reopen issues. But the Ninth Circuit ruled against Mr. Lemus-Escobar on all of them. And I'll try to get through them as quickly as I can. First, the Ninth Circuit can review a no-hardship finding post-Wilkinson if the only question is whether agreed-to facts meet the hardship legal standard because it's a mixed question of law and fact. We know, circuits, we know. But new here, the Ninth Circuit held it could review NACARA cancellation too. A different form. So that's something. Wilkinson is expansive. Now, only a limited class of older non-citizens can apply for NACARA, I believe, but just like regular cancellation, a CIMT conviction will bar the relief. So too on jurisdiction, quote, whether the BIA permissibly concluded that the record contains no indicia of incompetency asks whether a particular set of facts meets a legal standard, and that accordingly it is a question of law, end quote. All right, so competency challenges are largely fair game too in the Ninth Circuit. It's a mixed question of law and fact. Deferential review, though, just like on hardship post-Wilkinson, and therefore, like the Ninth Circuit, I'm actually going to begin with the competency-based motion to reopen. Pretty important here too, given that the IJ made an adverse credibility finding against Mr. Lemus-Escobar. I'll just read it all, quote, he suffered a significant head injury from a motorcycle accident many years ago, causing a large scar on the back of his head. That accident, along with past alcohol abuse, has damaged his memory, causing what doctors described as memory loss, significant memory impairment, and an inability to recall numerous events. Doctors have diagnosed him with memory disturbance and other things, including a form of dementia. One symptom of the syndrome is confabulation, a tendency to make up information that the person cannot recall. The person is not lying in any meaningful sense. The person truly believes the self-fabricated memory, end quote. Other issues, too, that if a judge was listening to it, might lead the judge to think that the person was lying. All of this was supported by medical evidence and testimony of family members. And recall, the BIA rejected this, in part in a motion to reopen and in part in the appeal in chief, holding that, quote, the record contains insufficient indicia of incompetence to mandate further inquiry into competency by the IJ, end quote. This was an abuse of discretion, held the Ninth Circuit. In the aggregate, there are at least indicia of incompetency, which under matter of MAM is what triggers possible additional agency accommodations. It's actually exactly what the BIA was talking about in MAM, explains the Ninth Circuit, and it warrants further inquiry by an IJ. That means it warrants remand. That Mr. Lemus-Escobar may have testified coherently during some of his testimony, as the BIA relied on, doesn't make up for all the evidence of his possible incompetency. It needs consideration, and maybe a safeguard? Like, I don't know, a finding that Mr. Lemus-Escobar is credible, notwithstanding his apparent inconsistent testimony? Stranger findings have been made in the competency world. Or here too, explains the Ninth Circuit, maybe the IJ would not have permitted Mr. Lemus-Escobar's asylum application to have been withdrawn if he had known about all this mental incompetency indicia, as apparently occurred. Quote, whether or not the petitioner has counsel, the BIA has placed an affirmative duty on the IJ to make a competency determination whenever the record contains sufficient indicia of incompetency, end quote. Repeat after me. An attorney is not necessarily an adequate mental health safeguard. So, there's the remand, out of the way. Now to all the denials. Where to begin? 1992. Mr. Lemus-Escobar files an asylum application which somehow doesn't get conclusively adjudicated until 2017, when his attorney withdraws it in removal proceedings. We already know that might be an issue because of the mental health stuff that's getting decided now on remand, but assuming no mental health problems, the IJ did not err in relying on counsel's position below that they were withdrawing the application. Quote, petitioner is generally bound by the acts of his lawyer, end quote. Moving on to cancellation, the Ninth Circuit saw no error in the denial because it agreed that shooting a firearm into an inhabited dwelling in violation of Cal Penal Code Section 246 is a crime involving moral turpitude. So yes, we've got an entire crimmigration analysis wrapped up in this decision. And the Ninth Circuit really puts the nail in the coffin of whether Loper Bright is going to change the CIMT definition of the Ninth Circuit. Heads up, it won't. Not at all, says the panel. Although footnote 4 does recognize that some Ninth Circuit precedent in the CIMT realm may no longer be good law. Check out that complex footnote and this complex issue on prior cases. Anyway, to violate the statute, the shooting into an inhabited dwelling, the defendant needs to intend to shoot, though they can be reckless in respect to hitting a target. Not sure what they need to know about whether the target is inhabited or not, but the Ninth Circuit doesn't seem concerned. How to do the CIMT analysis? Quote, we consider the actus reus and the mens rea in concert and on a sliding scale. For more egregious actus reus, a lesser mens rea suffices, and for a more intentional mens rea, a lesser actus reus suffices. So if you're more culpable, a less bad act is needed to make it a CIMT. The intentional shooting is a pretty culpable mens rea, explains the court. Intentional. And while it need only be reckless into as what you're hitting, and that's pretty much the lowest mens rea that can potentially qualify as a CIMT, it's still shooting a deadly weapon, and it's still an inhabited structure. Pretty bad actus reus, explains the Ninth Circuit. That is the shooting. Relying on lots of California Supreme Court decisions too. Meaning Mr. Lemus-Escobar is barred from cancellation based on what he did in 1988. And I guess NACARA. Turning then to some other motion to reopen bases, the Ninth Circuit held that it could review the BIA's mixed question of law and fact that the new evidence submitted wasn't actually new. Seems like new is a legal enough standard to the court to get review. So that's something. It just agreed with the BIA here. Still a pretty important holding though. And the same goes for whether a non-citizen has made a prima facie case for relief. So pretty important motion to reopen holdings snuck into this decision, which is a denial in many respects. The court then also held that it lacks jurisdiction to review the BIA's finding to deny reopening on the ground that it would deny cancellation as a matter of discretion. So, fine lines being walked as to what jurisdiction there is on motion to reopen review. The Ninth Circuit lays out its jurisdictional rule in summary here, so save this decision for review, circuit warriors in the Ninth Circuit. Maybe you can review whether a prima facie case was made, but if the BIA also denied a motion to reopen based on a finding that as a matter of discretion, the non-citizen wouldn't warrant the relief, well, seems like you're not going to get review at the circuit. That's a problem here because that's exactly what the BIA did. It denied reopening in part based on a finding that Mr. Lemus-Escobar wouldn't even possibly warrant cancellation as a matter of discretion. So all the other smart arguments made in this decision fall to the wayside. No review there. Finally, the asylum reopening challenge. Former counsel was thrown under the bus, and the Ninth Circuit actually saw a claim here, but it didn't see a prima facie case to asylum even with the new proffered evidence, so it affirmed the BIA's denial. I mean, we're arguing over the Guatemalan government's ability to protect Mr. Lemus-Escobar from guerrilla and drug traffickers in the early 1980s, which I think also affects the objective reasonableness of future harm to the Ninth Circuit. So, 46 pages single-spaced in, we're getting a sneaky good ruling for mental health asylum, withholding of removal, and CAD claims in the Ninth Circuit. Notwithstanding some of its recently bad precedent for non-citizens on similar issues, quote, petitioner's claim here is far more specific. He fears being hospitalized at one particular hospital in Guatemala, where patients are routinely abused. Petitioner's claim is not a nationwide generalized claim of inadequate access to medication. He fears direct physical violence while institutionalized, and his claim is supported by specific reports from credible entities. Under any sensible assessment of the record at the motion to reopen stage, petitioner established at least a reasonable likelihood they would prevail in establishing a reasonable fear of future harm. End quote. Similar ruling for Convention Against Torture remand, quote, he does not fear generalized harm from an inadequate healthcare system or from generally poor conditions in the hospital. He fears that he will be locked in the hospital and will experience what has reportedly happened to many others, specifically violent abuse, rape, and torture caused by those with a specific intent to harm, end quote. Oh my goodness. So turn your mental health case into all that in the Ninth Circuit. Some really sneaky good rulings for non-citizens in this case, if you're combing. And good luck, IJ, on this remand. Judge Zahari dissented on remand and notes, quote, another unfortunate snag in our congested and broken immigration system, end quote. But it's a remand, meaning congratulations in part to Thomas Perkinson and Enrique Arevalo for petitioner. I am absolutely exhausted. See you all next week. And that is Lemus-Escobar v. Bondi. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli, and Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. And you know, we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.